with the motion to disqualify special counsel, which was put over to today. I don't know if we're going forward on that today or not. And finally, the court inquired about the status of a motion for a bill of particulars. I informed the court at that time that I understood that Mr. Mello was working on it. And my understanding is he has since filed a bill of particulars. I might imagine that Mr. Bradel has some comments to make about that, but I guess we'll find out. So that pretty much covers, I think, what's
and in terms of,
from last time.
I know that you had filed, I'm sorry to interrupt you, but I know that you had filed notices of the discovery that has been provided up to this point. There were copies of letters that were provided to Attorney Bradel. What's your sense, ADA Cosgrove, of where discovery stands at this point on both cases?
Well, I think we're probably at the point, I would say, where 98% of the discovery has been provided. There are a few things that I want to do further investigation of. I expect that most of those can be cleared up fairly quickly. I will say that when I walked into court for the first time on this case for a hearing before Your Honor, I thought that discovery was almost completed then, and Mr. Bradel surprised me with a fairly lengthy list of things that he was missing that I have since done my best to respond to what extent to his satisfaction, I don't know. So we'll see what today brings. But I think most of the Rule 14 discovery should probably be provided fairly presently. And then I'll file a comprehensive list and the certification that I have done so. I want to certify that I've provided all the discovery until I'm confident that I have.
Understandable. And I know that you did file a response to the request for special request for discovery, that there were certain areas that you had outlined where there were objections to that, to certain requests, and also indicated whether they had been, they were in the custody and control of the Commonwealth at this point as well, too. So I'll hear.
Yes, and I hope I understood correctly that what Your Honor asked me to do was to respond to the motion, not that you had allowed the motion, that I was to provide it, although Your Honor is obviously prepared by reading the materials. You can see that from the letter that I provided Mr. Bradel that some of the discovery he asked for that the Commonwealth agreed to, I included right in the letter.
Okay, thank you. Attorney Bradel, what's your position on where discovery stands now?
Judge, I have a different view of it. There's a lot of really important things that are not provided. The first area that I want to talk about, Judge, is my client's phones and computers that were taken out of his home a very long time ago. And we have nothing in terms of the contents that was taken from my client. And that's a huge problem. And there's a lot of reasons why my client needs those items back. You know, he's a professional journalist. They took all of his work product from his entire career. And in there are confidential sources. There's personal communications. There's medical things. There's investigative things on the very same state police officers that are charging him here. So they have a self-interest and a conflict in getting into his devices. And they've kept these things for months and months and months.
Those were seized pursuant to a search warrant?
Yes, Your Honor. And we've never seen hide or hair of any of it. And now that brings me to my second point, which is that the government is bound by the strictures of preventive medicine here. It's the case that requires when the government seizes items that implicate an attorney-client privilege, and we would contend other privileges as well, such as the attorney, as the journalist privilege, husband-wife disqualification. There's all sorts of privileges that would be implicated by the fact that they took all of his electronic devices. And, but at a bare minimum, preventive medicine talks about attorney-client privilege items. And Mr. Carney has been involved in litigation as of the time of the seizure, unrelated to this. Civil things, restraining orders, other cases where he's the victim, all kinds of attorney-client communications are filled in his electronic devices. And we haven't been given a copy of that. And at the same time, the government is supposed to comply with preventive medicine, which they haven't, and I'll get to that in a second. But nothing in their duty to comply with preventive medicine stops them from giving us back, either give us back the items, because we know they took a mirror image of everything, give him back his physical items, number one. And if they don't want to do that, if they want to trip him up somehow and not give him the items back, they needed to give us the discovery by May 8th, your Honor's first deadline, by June 13th, your Honor's second deadline. How about by today? We still don't have anything in terms of my client's phones. And they could have given us.
Let me just stop you there for 88 Cosgrove. Is that within the 2% of the discovery that's still outstanding?
No, actually, Your Honor, Mr. Bradle brings up a point that I was intending to address with you a little later this afternoon, but since we've come to it now, let me address it now. There are actually 5 search warrants involved in this case. Two of them involving a different party, and 3 of them involving the defendant. One was for his home, one was for things like cell phone, portable devices, and one was for his vehicle. And I just have a little, read you a little excerpt, one paragraph from a 32-page affidavit that will give you flavor, I think, of what was alleged in the warrant. I have it.
While you're looking for that, is there a reason why the items that were seized have not been copied and provided as part of the discovery?
Yes, and I will explain that. Apparently don't have it, my apologies. Shortly after the items were seized, and this predates my involvement on the case, so I don't know if Attorney Bradle wishes to comment on this point. My understanding was that Attorney Bradle was in touch with Attorney Mello and said, can't go ahead and search these because we need a taint team procedure under preventative medicine. Attorney Mello agreed to that and set about finding some personnel for the taint team, which he identified. I was actually originally brought onto this case, Your Honor, to provide advice on legal issues, among them putting together a motion to set up a taint team. Before I could get oriented and underway on that, Attorney Mello experienced some personal illness, so I have been pressed into other matters of which Your Honor is quite familiar, and that has taken me away from putting together a motion for a taint team, although I have completed a draft out for several people to look at, and I hope to file it shortly. But as Your Honor knows, the normal process with the taint team is that a forensic investigator and assistant district attorney or assistant attorney general in the office who are not involved in working on the case or the investigation in any way is assigned to do a preliminary screen to filter out possible attorney-client privilege materials, and then the specially assigned assistant DA, who is on the Taint team, looks at those materials, makes an initial determination of whether they contain attorney-client privilege material, and then provides that list to the court along with a copy of the seized items to the defendant, or at least to the person whose electronic devices are being examined. In this case, it's the same person. That person and his attorney then have an opportunity to examine the list with the aid of copies of their own devices and come back and make an argument to the court as to other things that should be excluded that they claim the so-called Taint team is. The court makes a ruling on that. Then once that's taken care of, the results are turned over to the prosecuting team and search commences of the materials that are not deemed to contain the attorney-client privilege. I think we are almost ready to proceed on that. In this case, because of the district attorney's desire to separate this from another ongoing case and to have a special prosecutor assigned to the case, we don't have the option of using another ADA in the office or another forensic examiner who works for the DA's office for the Taint team. That would more or less defeat the purpose of the special prosecutor. So we have identified outside people to do this. I did happen to speak just yesterday to the person identified that we intend to identify as the forensic examiner to make sure that he was still on board, since it's been a while, as Mr. Bradel correctly points out, and I'm advised that he is. So I would expect that hopefully by the next time I'm before Your Honor, I will have a motion to file to approve the procedure going forward. And I think once it's approved, I'm sure I can work out with Mr. Bradel arrangements to provide clones of the items that were seized. Because the procedure has not been in place, we have not moved forward on it so far. I would say that listening to him, I'm quite sure that we would want to keep the original items that were seized for chain of custody issues. And in case there is a allegation, I'm sure there wouldn't be, that we have tampered in some way with the devices. But I don't see any reason why we couldn't fairly soon provide clone materials. Now, as I listen to Mr. Bradel, I don't have any problems. I'm sure we won't have any problems if Mr. Kearney has had a case, a civil case somewhere, and he's had communications with his civil attorney. We don't have any interest in that. We don't have any problem bringing that up. If he's going to claim that there are 16 other kinds of privilege that should be applied, and I'll just mention one, journalist privilege. I think while I'm preparing my motion for the court, would move things along if Mr. Bradle prepared a motion setting forth the other privileges that he claims his client is entitled to, that the Commonwealth cannot search for, and we can take them up at the same time, and Your Honor can make a ruling on it. I don't think there is a journalist privilege in the Commonwealth of Massachusetts, for example, so I'll be interested to see the case law.
Okay, I know you weren't here at the April date, which was April 23rd, but there was discussions at that point with Attorney Mello about the Taint team and the things that were happening. So I can.
I was not here, and to be honest,
so that's
I have no idea what he said.
So there was reference to it at that particular time. So I would encourage you to get that filed as quickly as possible, so that way we are able to move on that. Obviously, that's part of the discovery that's involved in this case. So we'll set a deadline by the close of today when that needs to be filed.
All right, I hear Your Honor loud and clear.
Thank you.
Let me just give you a couple of dates, Judge. The phones were taken on October 11th, 2023. Exactly 9 months today, 9 months. And in November of 2023, November 6, 2023, I asked Attorney Mello in an email, can you just take a mirror image of all the computers and phones? Pretty routine in these cases, and the devices get back to the defendant. I can stipulate that all those devices are his devices or family devices as appropriate, if that's your concern. Otherwise, I think it just looks like you're going to try to shut down his reporting by not giving him the tools of his trade back, in essence. That was, I sent that to him November 6th. I got a one-word response. We're unable to release any devices until all matters are resolved. So that was their position back in November of 2023. The government proceeded as if the requirements of preventive medicine didn't even exist, Your Honor. I raised the issue, and after a bit of squirming, frankly, the government finally said, okay, we agree that preventive medicine applies. And now here's where counsel's suggestions, and again, as I've said many times, I appreciate that counsel's new to the case and had nothing to do with this stuff, but nonetheless, it's in his lap today. And preventive medicine requires the government to affirmatively come forward to the court, and I'm just going to read it. Preventive medicine judges from 2013, and it's something that we all need to know about. And it says, we conclude in the future, when the Commonwealth seizes devices, et cetera, that have privileged materials, the Commonwealth must present to a superior court judge and obtain judge's approval of the search protocol to be used, and specifically the procedures proposed to protect against searches of privileged communications between the defendant and his attorneys. Court supervision is necessary because the harm to the defendant could be irreparable if the Commonwealth viewed privileged materials, even if only by accident. Further, unless the Commonwealth can demonstrate a compelling contrary reason, the defendant must have an opportunity to be heard before the judge approves a particular search method. So there needed to be a hearing a long time ago, and the Commonwealth needed to file a proposed search strategy, and then we were to be heard under preventive medicine. And none of that has been accomplished. Mr. Mello, I don't exactly remember when, but it was at least 6 months ago, said to me, what do I think about Judge Veery, who we all know, and Mr. Verno as Taint team people? And I said, that's great. And I reminded him months and months ago about preventive medicine and that you need to file your proposal so we can trigger a hearing. And that's where I was going to bring up what I alluded to here, which is that in Mr. Carney's particular circumstances, Your Honor, he has much more at stake than just attorney-client privilege. He has confidential sources. He has confidential sources in his phone about this very case, people that have bravely come forward, law enforcement people that have bravely come forward to say, hey, Aiden, here's what's going on behind the scenes. And now the government is in a position here to try to invade that. So there's a lot more than just attorney-client privilege, but that's
Well,
something
certainly
it's gotten to in the future.
Absolutely, and
And,
certainly
you know,
ADA Cosgrove understands the process and the procedure. The question now is getting it done. So it needs to be filed. I appreciate your suggestion that you weigh in as to any issues that you think are privileged information and put the Commonwealth on notice of that. And that I'm going to require that the motion be filed on or before August 8th.
And Judge, meantime, this is very important.
And obviously, let me be clear too on that particular issue, that if there are issues that you were concerned about, that of inquiries that were made that don't follow the procedure, that's a separate hearing that will be addressed at a later date.
I appreciate that. Thank you for raising that, Your Honor. And then that's all well and good, and I appreciate being heard on all this stuff. It doesn't change the fact that this is a one-way street. They're not allowed to see certain things in my client's phone. Obviously, my client is entitled to get his property back, whether it's, we want the actual items back because we know they don't need them, and I'm willing to stipulate. But if the court's not willing to go that far, I respect it. And I would ask, after 9 months, that he be given back the tools of his trade, be given back the contents, the clones of the items, forthwith, I mean, immediately, so he can get back to what he was doing. And then that will put us in a much better position to say, I can go through everything and say to the court at that preventive medicine hearing that we're supposed to have, that, Judge, here's the very sensitive issue, this, and, you know, I may even be, you know, ex parte at sidebar, I don't know, but there's very important rights at stake here and issues at stake, privileges at stake. And so we would like to get that information at a bare minimum as soon as possible, and I ask you for a ruling on that.
Commonwealth, what do you say to providing a copy?
Well, preliminarily, let me say I can't say that I've noticed that Mr. Kearney has suddenly gone dark on his more than weekly web presentation since these items were seized. I would frankly resist, Your Honor, providing a copy in advance of filing the protocol and getting it approved by Your Honor. But I will look into it. That's as far as I'm willing to go at this point.
If I may, what possible basis could they resist after 9 months of not giving it up, refusing my request, refusing my stipulation, not following preventive medicine? I don't think the Commonwealth is in any position whatsoever, as they stand here today, to be telling you what they want to do. I think they are pretty lucky they're not looking already at a motion to dismiss for lack of prosecution for not giving any of this stuff for 9 months. So I would ask that you order it within 14 days, and if it's not complied with, that Your Honor dismiss the case for lack of prosecution.
Okay. I've set
No, I'm not telling.
It's okay. I've set that motion is going to be filed by August 8th. We're going to address it at a further hearing that I'm going to give you until August 1st to advise the court and Attorney Bradel whether that there's an objection to providing a copy in advance of that Taint team. I'll give you the opportunity to respond to that. And Attorney Bradel, if there's something you want to file at that point, be happy to address it the next day.
Thank you, Your Honor. So Judge, that's the matter of the phones. And, you know, I see no legal basis. The last thing I'll say on it is no legal basis, Your Honor, for the government to, after 9 months, not give him his phones just because they can't see them. It's got nothing to do with Mr. Kearney getting his stuff, and that's all I'll say on the matter, Judge.
Yep.
And we would be moving for that.
In terms of other discovery, where do things stand in your mind?
Yes. Jail calls, Your Honor, and this dovetails with my motion regarding cross motion for sanctions, et cetera. It involves the jail issues there, Judge, where it was determined that everything that was asserted by Mr. Mello in that motion, where he personally went after me, was shown to be completely false.
I know that you filed a supplement to...
And my supplement, Judge, yes. And so against that backdrop, Your Honor, apparently the government has recorded a plethora of phone calls of my client. And at this point, I don't know who they recorded and who they didn't. And they changed, the jail changed their mind about whether paralegals could listen and lawyers and investigators were okay, but paralegals weren't. They were all over the place. In any event, we don't have any calls that they recorded of my client talking to whoever. And that's another huge hole in the government's position that, oh, everything's 98% complete.
Attorney Cosgrove.
Well, Mr. Bradel always has an extensive list, and perhaps my memory fails me, but this is the first time I recall hearing anything about a jail call. I'm not aware. I've looked, I've had reason to look, but I'm not aware of any jail calls. We have conversations by Mr. Kearney, and I'm sure if they were recorded, that they were recorded pursuant to the procedures that people in the custody of the House of Correction are advised of at the time they become inmates and are given access to the phone.
So obviously, if those exist and that they were secured by the Commonwealth, that would be contained within automatic discovery under Rule 14 as statements of the defendant and would need to be provided.
I'll inquire.
Thank you. Attorney Bradel. Anything further on discovery?
It would be helpful, Judge, if the requirements for certificates of discovery were accomplished as well, so I can see what the government thinks they've given us. And
well, he's provided you. Those letters have been provided that I've seen copies of what is the notices that have been given directly to you, that have been filed with the court, and ADA Cosgrove has indicated that he will file a certificate of compliance once discovery is complete, but with an exhaustive list of everything that was previously provided.
Thank you, Judge. And the government's attempted to comply with this, but I didn't quite get it. There's a 2/22/24 grand jury transcript that we had mentioned earlier, and I know counsel thought that they were giving it to us, but it wasn't the right thing. So I'm asking for the 2/22/24 grand jury transcript. I believe that's Ms. Gattani's testimony from that day, the civilian complainant, and we don't have it, and we need it. And so I just ask that counsel provide that forthwith as well.
Okay, well, I know that ADA Cosgrove, you have it because you reference it in your filing on the Rule 17 issue and summarizing.
May 8th, I sent Mr. Bradel a letter.
That's what I mean, Judge. The counsel tried to comply. It just wasn't the right thing, I think, that they sent. Or we couldn't open it. I forget the exact issue with it or whatever it was, but we didn't get it. And so I'm just asking for that it be sent. It was either another date or something.
Another copy or get another copy. I'm sure
it's not that document.
Okay. Any other outstanding discovery issues?
There are items, Judge, that we can't open, that don't have the right driver, that can only be used on a computer that has like 1998 Windows. You know, we went through all this. Counsel suggested maybe some of this is user error. We have the most experienced computer people. They figured it all out. The Celebrate stuff was given to us with some reader from like years ago. Doesn't work, and we're working on that. There were some other video items that we can't open, and I'll just keep trying to work with the Commonwealth on that.
It's not unusual that exactly. It's not unusual that happens with the number of players and proprietary software that's out there. So I encourage you to continue to work together on that.
I will just say that the readers provided, the readers that we used to open those documents, and I'm not aware that we have other readers, but Mr. Bradel has indicated a willingness to continue working on this, and I'm sure we'll do our best to meet him halfway.
Well, you know, I appreciate that, Judge, but the best was supposed to be done May 8th. The best was supposed to be done June 13th. And here we are again. You know, I'd like a little more than just we'll do our best. I mean, could I ask the court to impose a date certain, as we lawyers like to say, so that I can know when this is going to come?
I don't think it's my responsibility to buy software from Mr. Bradel. We've provided him with the software that we use for the documents, and he's having trouble with it. We'll assist if we can, but I don't think our obligation extends to being computer technicians.
It does extend to providing discovery, and if the means they provide it with, Judge, does not work, they need to find another means.
Good. Continue to work together on that issue.
Thank you.
Are we ready to move on to the Rule 17?
Rule 17, Your Honor, yes.
Okay.
Judge, if I may, I would file this one under a no-brainer that this is a Rule 17 situation. First of all, the notion that the government can oppose a third-party request, I would submit inherently violates my client's due process. What does the government, what business is it of theirs to defend or to fight off a request to a third party for non-privileged records, Your Honor? And I would point by analogy to the civil side of the docket. As the court sees all the time on the civil end of things, a civil lawyer can file a record keeper deposition to a record keeper at Verizon and have it notarized and send it off and get any sort of non-privileged records they want without taking all this judicial time. And so here we are where my client's very liberty is at stake. We have the government trying to trip us up, trying to argue that it's not relevant, trying to argue that we shouldn't have something from a third party, and interposing all of these factual arguments that I read in counsel's submission about he said, she said, Ms. Gattani said this happened, Mr. Carney said that happened, blah, blah, blah. What we have is Exhibit B to my submission, Your Honor, that Detective Tully wrote in his report, and I have it highlighted here, it's the first full paragraph on the second page. Mr. Mello, and again, this makes Mello a witness, and it makes the Verizon records absolutely germane and important to my client. Ms. Gattani at 10:30 at night calls the special prosecutor, Mr. Mello. They have a conversation. She says to him that Mr. Carney's at her apartment. Mr. Mello then forwards the call to Detective Tully. Detective Tully's listening in on what's going on in the house, says he can't quite understand anything being said because the voices are muffled. He's trying to listen in, unbeknownst to Mr. Carney. After several minutes, he's listening for several minutes. At 10:48 p.m., Lindsay sent me the following text message. Ken said to call you, but I can't now. Ken, whether he's on there on a personal basis here, Ken said to call you, but I can't now. He's knocking on the bathroom door. I have to go back out. Please don't call or text and tell Ken not to because he wants to see my phone. I'm deleting our calls and texts right now. Don't respond until you hear from me, please. So it's memorialized in a state police report that she, Tully, and Mello are all talking together and are all privy to Ms. Gattani destroying evidence. And there's nothing in the police report that you might expect to see where Detective Tully might say, whoa, don't destroy evidence, just leave it, figure out something else. There's no mention of anything when she says to him that she's going to destroy evidence to not do it. So the evidence is gone. And we know that, Judge, from the discovery that we have been given, that there are messages missing. And that's what I mean when I say this is a complete no-brainer, that we need to go to Verizon to see if we can get messages, records to show that there were text messages there, that there were phone records that are gone from the actual device.
Do you have a download of her device?
Yes, we do, Your Honor.
And
there are missing sections, absolutely, and it corroborates it corroborates the detective's report. You know, he wrote it, that she said this, that she's deleting things.
And doesn't that provide you with an ability to cross-examine that witness about deleting things and removing particular items?
I'm not worried about the cross-examination, but I want to see what was said.
Yeah.
You know, what if that will determine, is Mello and Tully putting words in her mouth? Are they saying what to do? Are they, you know, we contend, and I should rewind a little bit, Judge, we contend that this whole visit was a setup of Mr. Carney. And they delivered a summons to Ms. Gattani that day after a very contentious court hearing on a Friday, as I recall. They delivered a summons to Ms. Gattani for no particular reason that I can see. She wasn't a witness in anything. They delivered a summons to her. She got right on the phone to texting Mr. Carney, and we have all these text messages that telling Mr. Carney that she got summoned, and the upshot of it is that she says we should do it in person, and the last text message is, I have it right here. Ms. Gattani says to him, the last line, but I think we should save anything else for in person. And my client says agreed, in person. And she has him come to her house. So this whole thing was to lure Mr. Carney over there. And it was his first taste of freedom. And then they revoke his bail for this incident. And we contend the whole thing was a setup. And that is borne out by the fact that these two were on the phone with her at 10:30 at night, and evidence is deleted. And we need to go beyond Ms. Gattani, Mr. Tully, Mr. Mello to the carrier to see what if anything is there, if anything is still preserved.
But you're not going to get content. You would get records showing that there was either text communication, you know, a length of the message, correct, or phone calls.
No, these carriers are all over the place. Some of them give you content, some of them don't. Some of them will show that there was something there that was dismissed, or deleted rather. They're all over the place. But in terms of a discovery request, you know, these are non-privileged third-party records. And I just wonder, why is the government scratching and screaming that we can't have this stuff? It makes me wonder even more what is in there. And it's incredibly important. It's germane to the case. It's an admitted destruction of evidence. So we can't just rely on them or cross-examine that they destroyed evidence. We still have a chance to see what the evidence is.
And how do you go from that particular date to the expansive request that you've made?
Well, I think it justifies an examination into the relationship here, the ongoing relationship between the district attorney, the special assistant district attorney, who she calls Ken, and Ms. Gattani, and how much communication was there, and to what extent is he a witness, and to what extent is he participating in what we contend is a plan to lure Mr. Carney to the house and then get him in trouble and revoke his bail, which is exactly what happened. And this specious assault and battery charge that was the alleged violence that Mr. Carney was supposedly wreaking on Ms. Gattani was abandoned by the government. They didn't even indict it. They indicted the other two charges, but they didn't even indict the assault and battery charge. So all this is evidence that there was a setup here, and that the prosecutor was involved on the phone with them at 10:30 at night. So, and it's memorialized in their report that evidence was destroyed, deleted, and taken off the phone. So that's, I don't think we need to go any further than that, Judge, in terms of all the Lampron requirements. It's just a discovery request for non-privileged items. So I would ask you to allow it.
Thank you.
Thank you.
Kamala?
Well, I will resist the temptation to make light of counsel's comment that his motion is a no-brainer. I agree, but probably not for the reasons that he set forth. I do give him points for novelty. It might be nice if the Supreme Judicial Court had not set forth a Lampron procedure in criminal cases, but it has. And traditionally, the Commonwealth is entitled to be heard on Rule 17 motions, and we are being heard. So I'm not quite sure that it's a Rule 17 motion that we are hearing, because what I hear Mr. Bradel say is in terms of discovery request, and the case law is quite clear that a Rule 17 motion is not a discovery motion. It's a motion to acquire evidence after a very specific set of showings set forth in Lampron and successive cases, that the evidence exists, it's material, that it's relevant, that it's admissible, and with some I never can say that word, I'm sorry, specificity as to what it's going to produce, not, well, this looks suspicious, so let's see what we can find out. It's not a discovery motion. I listened to Mr. Bradel, and it seems to me he omitted the elephant in the room, which is, as I alluded to in my response to his motion, when he looked at Ms. Catani's phone, and or maybe perhaps independent of that, I'm not sure. In any case, he asked for text messages between Lieutenant Tully and Ms. Catani. I spoke to Lieutenant Tully about it. He said, yes, I can bring those up on my phone and print them out for you. So I said, would you do that, please? I'd like to take a look at them and reach my own opinion as to whether or not they are discoverable. He did that. I said, yes, they're discoverable. And I turned them over to Mr. Bradel. So all of the deleted text messages between himself, between Lieutenant Tully and Ms. Catani, he has. They've been provided in discovery. The relevant time period, you can slice it how your Honor wants, but I would indicate there's probably about 10 texts back and forth. Beginning at 6:27 p.m. on December 23rd, when she calls and asks for a phone number. There's some conversation about that. Eventually she gets to one of the few, I think, substantive things as to what happened on that night, which is this. Ken said to call you. This is Saturday, December 23rd at 10:48 p.m. Ken said to call you, but I can't now. He's knocking on the bathroom door. I have to go back out. Please don't text or call, and tell Ken not to, because he wants to see my phone. I'm deleting our calls and texts right now. Please don't respond until you hear from me, please. And that's pretty much it. The following day, on December 25th, which is also pertinent, she indicates that to Lieutenant Tully that she just got a call from the Holden police sergeant who told her that the defendant told them that he would be coming to the station to turn him in when he didn't get. And that's about it in terms of the communications. But whatever the communications are and worth, they're all turned over. So what's the need to try to get them again from Verizon? And certainly there's no need to get this universe of other materials that he wants to do. I understand he wants to push this conspiracy theory, but there is virtually nothing to support that. I would just say, apparently, for Mr. Kearney, the old adage applies: if all you have is a hammer, everything looks like a nail.
Thank you.
There's nothing to support that. It's the government's own police report that says text messages were being deleted. And
they are. They haven't.
We don't have to, especially in this day and age, what's transpired in this courthouse recently. We shouldn't have to rely on the state police for this, Your Honor. There is a report that says text messages were deleted. We're going to turn around and just rely on a printout from the implicated officer? That's outrageous. That's ridiculous. I'm sure Verizon appreciates the government wanting to save them a little work, but tough. We need to know from a third party what's going on here. I don't want the mistakes of the Karen Reed case to be repeated here. There's nothing wrong with this court doing what's done in every civil law office in this state countless times a day. And I know we have to.
We're working in a different environment, Attorney Bradel, as you know. So the civil rules don't apply here. That the court has to apply the Lampron-Dwyer protocol in making sure that all of those criteria are met. So
I understand.
That's what I'm going to.
And we have, and we do, and it's never this clear, where it's in the report that things were deleted. And so we're going to rely on the actors to say, like Howie Carr likes to say, nothing to see here. Nothing to see here. Move along. Here's your papers that we printed out for you. That's ridiculous, and it is outrageous. And there is nothing. The standard for this court to order this should be about a 60-second argument. And the government always fights these things tooth and nail for whatever reason. Why they want to suppress the truth? Why they want to suppress what could be out there is completely inconsistent with their duty to do justice. And I would ask that you allow it under Lampron, Your Honor. Thank you.
I don't think it's productive for me to respond to that. I think, Your Honor, the gist of my argument, I would just make 2 points. One, I don't think Lieutenant Tully has been implicated in anything. And I take issue with that comment. And two, if Your Honor should decide to allow the motion or some portion of the motion, I would ask the court to restrict the use of whatever is developed. If the names and telephone numbers of the people, particularly from the earlier conversations that Ms. Catani has been talking to, are not things that should be spread on Mr. Kearney's entertainment hours.
Thank you. I know that the record holder also has counsel present and has filed an objection to the release of those particular records. Counsel, do you wish to be heard further?
Just briefly, Your Honor.
Thank you.
We do agree with the state's argument. Ms. Catani has very serious concerns for her privacy if this data were to be released. Ms. Catani views the current Rule 17 motion as an attempt to continue to victimize her even now as the indictments against the defendant are pending. She adamantly opposes any further attempt to access her private data or personal information. This is an expansive request. She believes it is a fishing expedition. She does have medical information on there. She has her minor children's information on there. So for those reasons, Your Honor, we're asking that you deny the defendant's motion.
Okay. All right, anything else we can address this afternoon?
Bill of particulars, Your Honor.
I know that ADA Mello had filed a response.
So the government agreed to my motion, Your Honor. My motion is a particularized motion. It raises constitutional issues. And just a couple of things from my motion, Judge. This type of activity, which we contend is protected journalistic First Amendment activity, has never been before criminalized or charged in the Commonwealth. So this is a unique situation, Judge. This isn't just like another case of this or another case of that. This is a unique situation. That's why I filed this motion for bill of particulars. We asked the government with respect to the bill of particulars that we said that we must know what prior heretofore legal and unprosecuted journalistic activity they're now perceiving as criminal. What's the activity that they're saying is criminal? They agreed to provide that. We said we need to know what aspect of the enumerated incidents allegedly comprise witness intimidation or picketing, and what evidence the government claims exists to that effect. The government agreed to provide that in a bill of particulars. Then if we look at what they've responded to on June 13th, I looked through this document, Your Honor. It goes through each of the indictments, the 16 indictments, and the 23 case. And I think it's a cut and paste job. I don't believe there's literally not one sentence in here that was an original sentence created beyond a cut and paste job from the indictments and the statute. And it repeats, it doesn't even specify the dates and times. It still sticks to the indictment verbiage of diverse dates. So we still don't even know what they're talking about. So the government, to avoid an issue or whatever their reasons were, they agreed to my motion. Then they did not comply with my motion. They cut and pasted 16 indictments with plugging in the statute. So they gave me not one or two things, not a dozen things. They gave me zero information. That's their response. So I would ask that you order a proper response within 14 days.
Thank you. Hey, Cosgrove, I know you didn't draft the document, but do you want to be heard on it?
I do, Your Honor, and if Your Honor would indulge me, if you have a copy of Mr. Bradle's original motion there, could I look at it for a moment?
I have an extra one here I can give you.
Thank you very much, Mr. Bradle. Appreciate that. So initially, I may be splitting hairs. My recollection is that the court endorsed this motion as unopposed rather than assented to. That may be a small difference. And I will concede that given Attorney Mello's response, perhaps the better part would have been to oppose the motion and suggest that a bill of particulars is not necessary or appropriate in this case. And I'm not sure at this point quite what Mr. Bradle is asking for a remedy, but before I come back to that, I will say that despite the fact that Attorney Mello, on behalf of the Commonwealth, repeats that the information is readily available to the defendant in the grand jury minutes and the police reports and other discovery provided, that statement, I think, is indubitably correct. There are basically two charges in this case with multiple victims. In almost every case, the alleged victim testified personally before the grand jury and answered not only Mr. Mello's questions, but the grand juror's questions. So it wasn't a case of a police officer coming in and simply reading a police report. And if Your Honor will bear with me for a moment or two, I just picked out one victim at random. There's obviously 5 or so different sets of grand jury minutes, but I'm going to refer to the grand jury minutes of December 5th of 2023. And I am going to pick at random Matthew McCabe. And Mr. McCabe testified as to 2 incidents involving Mr. Kearney and himself and his wife. Beginning on page 42, he described an incident where he was at a lacrosse game where his daughters were playing against a team in Bill Ricker. He was asked to describe what happened while he was there, and he replied, Aiden Kearney showed up to my daughter's lacrosse game. My wife and I, my daughter and other friends were in the stands. Previous to Aiden coming in, we noted somebody videotaping us who happened to be Aiden's guy. Skipping over, Aiden came in from the top of the bleachers and approached us to engage regarding the Karen Reed case. And asked what did he say and who was he saying it to. Originally engaged us, you know, fancy seeing you here. I forget how he started the conversation. But he was asking questions. I believe he was asking my wife questions pertaining to the Karen Reed case. And then the verbiage I'm skipping over. It's in evidence in the Karen Reed case, and then he might have asked if we were smarter. My wife was smarter than Karen Reed, and I believe I responded to him that his question was answered in court already, and that he should be, you know, should be looking at what was said in court and not engaging us. Things got a little hostile as voices were being raised. Other people were asking him to leave. As I said, another gentleman was there videoing it. And then as I left, I believe he was screaming, we were cop killers or we're murderers again. I don't know the exact words, but they were along the lines of cop killers. I remember murderers. We are cop killers. We are murderers. And proceeded to say that as he left, walked out of the parking lot. Asked how that affected him emotionally. He answers that question. Then he describes another incident where Mr. Kearney approached him when he was at Superior Court. He identifies himself as a witness in the Karen Reed case. And then he goes on to describe a so-called rolling rally where Mr. Kearney and his crowd of followers, the witness says it could have been 50, it could have been 70, I don't know the exact number. They showed up at our house with my wife, myself, and my two older daughters. We stayed in our house. Aiden came out. I believe he had a blowhorn and stood in front of my house again. Don't know all the wording, but believe he was just there engaging and yipping about the case again. We are murderers. Murderers live in this house. Cop killers live in this house. There were a number of different individuals there. One walked up to my Ring camera and put his face up and said, I think we're going to jail. And it goes on in that vein, Your Honor, very specifically in describing these two incidents. And apart from that, Your Honor, you had the testimony of Lieutenant Tully, and he was there to introduce the video. Mr. Kearney is proud of these outrageous attempts to bully witnesses from testifying, and he features them on his show. So the grand jury was treated to a couple of free shows of Mr. Kearney's various shows portraying himself in the very act that was just described by the two witnesses. And in addition to that, there's the police report from Lieutenant Tully and so forth and so on. If there is one thing in the world that is not necessary to have a bill of particulars for, it's this case. And I would just ask the court to strike the allowance of the bill of particulars or let it stand as is. As I say, it's a little unusual, but it's a totally fair response given the circumstances in this case. If Your Honor is going to order me to make an extended or further response, bill of particulars for these 18 indictments or however many there are, they're all along the same lines. I'm happy to sit down and send the district attorney a bill for my billable hours of 6 or 8 hours of transcribing all this stuff from the grand jury minutes and the police reports and the witness testimony. But I think it would be more productive to spend my time on some of the other tasks that Your Honor has set forth for me.
Thank you.
Your Honor, this is the first time this has been prosecuted. If this is so obvious what the wrongdoing is here, how come the Norfolk County CPAC unit hasn't made hundreds of arrests on this? They only arrest Mr. Kearney for this. This just happened the other day. It was all over the news on NBC when a reporter went to the Proctor's house and tried to ask questions and shouted questions at them. She was told to F off and that to get off the lawn, and she wasn't even on the lawn. You know, nobody arrested her. There's 50 people at the rolling rally. Why is only Mr. Carney arrested? They are targeting Mr. Carney. They're inventing crimes. That's why, in this particular case, we need a bill of particulars. And let's just back up. They agreed to it. What are they asking you here? That they're trying to say, never mind? Do they want a do-over? Do they not like their deal they made? Does any commitments matter to this Commonwealth prosecution? I mean, what are they doing? The court ruled on this already. We have a ruling that's been entered on the docket, and now they want to squirm out of it. You know, enough. They need to respond, Judge. They agreed to respond. They're still not even specifying the dates. They're still sticking to diverse dates. Oh, on diverse dates, Mr. Carney did this and that. So what about what counsel read? Okay, what part of it is a crime? We've never known this before. Reporters can ask questions. That's what they do. Reporters have to be tough when they're dealing with corruption. Reporters have to be tough, and they get vindicated sometimes, Your Honor. Look what happened to Mr. Proctor in this case. A lot of that is from Mr. Carney. And you have to be tough to ask these questions. You have to be tenacious. You have to get in people's faces. You have to ask them 50 times, so maybe the 50th time they might answer. And I think there's a few journalists in this room that might agree with me. And there's a few journalists in this room that might be concerned that this is going to be a crime. And we need to know, when the government decides to invent a new crime in an insanely broad, unconstitutional statute, they need to have their feet put to the fire as to what are they saying is the crime here. This statute is the most broad statute probably in our criminal books, Your Honor, that talks about the way to do this. People that announce their intention to go to a court proceeding are now all of a sudden have this special status. And the ways that you can violate the statute, you can invoke emotional harm, economic harm. Does that mean that if I say, I'm going to sue that person, they're lying, I'm committing witness intimidation because I'm threatening to commit economic harm on the person? The statute is crazily unconstitutional, insanely overbroad. It's going to get struck down, and the government here is trying to use it. Let's be real here. The government is trying to use it to shut down Mr. Carney, who was making all sorts of headway against the state police, the district attorney's office, the Karen Reed investigation, and they're trying to shut him down. That's what this is all about. They took this statute that's never been used this way before, and they just apply it to him. So that's why we need a bill of particulars, Your Honor. That's why I filed a 3 or 4 page thing alleging constitutional issues. They agreed to it, and then they completely blew off compliance. And that's the posture here. They're asking you for a do-over. I don't know what's going on here, but we need to know those things because it's a brand new, it's a brave new world.
Let me ask you this. Does this affect your ability to file the motions to dismiss that you indicated you were going to file on the last day?
It does, Your Honor, because I need to know what they're saying is the crime and what they're saying is okay. You know, we're at the point where we need to go to the government to know what's okay now under the First Amendment in Norfolk County. Can we use a bullhorn? Can we bring 5 people out to protest? Can just one person protest? Do you need to be a certified journalist with a fedora and a press card? Or can you be a regular person and still have the benefit of the First Amendment? We don't know that in DA Morrissey's county. We don't know that. And that's why I need a bill of particulars. What are they saying is the wrongful behavior here, Your Honor? We don't know. I think that maybe these journalists might like to know too. Some of these journalists are pretty brave when they get in people's faces who they think are corrupt, killers, criminals, people who have newsworthy information. That's what this country's all about, Your Honor. And they are trying to shut it down. And they should, the court's the only bulwark we have. And they should be held to account to make us aware of what they're saying is the crime here, given the breadth of the incredible breadth of the statute, and given it's shocking when you read everything. It's behavior that you see teased on commercials at night when you're going to watch the news at 11 o'clock at night. You see something like, you know, Ted Daniel on the news at 11 tonight. He went to so-and-so's house and got the story. You know, Ted Daniels doesn't get arrested, and anybody else doesn't get arrested. Anybody sitting in the gallery doesn't get arrested. Mr. Carney gets arrested. He gets shut down. They steal all of his stuff. 9 months later, they don't give him his stuff back. They still want to stall and say, oh, we can't give him his back.
We're not going to rehash all the prior arguments.
You get it.
I'll review the
Thank you.
I'll review the bill of particulars. If there's anything that needs to be supplemented, I will advise both sides.
Thank you. Could I just say 3 words, 3 sentences in response to him? I hear Mr. Bradel say that the statute is unconstitutionally broad. I hear him say that the Commonwealth is engaging in selective prosecution. And I hear Your Honor asking him, need a bill of particulars to file a motion. I'm quite sure the motion's involved, but certainly you don't need a bill of particulars to ask for a ruling to the court as whether a statute is unconstitutional. And you don't need a ruling on the bill of particulars to make a claim of selective prosecution. And you also don't need a ruling on the bill of particulars, and I don't know if this is what Your Honor had in mind, because the last time we were before Your Honor, Mr. Bradel indicated that he wanted to file a McCarthy or an Odell motion, but he couldn't do that because he didn't have the discovery. We've got all the grand jury minutes now, with the possible exception of one that I thought he was provided that I said I'll get him tomorrow. Bill of particulars doesn't enter into a McCarthy or an Odell motion. It's strictly limited to the evidence that was presented to the grand jury. So I would just ask the court to take with a grain of salt all of these claims. Mr. Bradel has all these wonderful motions that he could file. If only the Commonwealth would jump through yet another 6 hoops for.
Thank you. All right. So Commonwealth, by August 1st, you'll advise the court whether you'll be able to provide a copy of the phone extractions, the computer extractions, or whether that will need to be further addressed. Also, the motion for the...
By the phone extractions, Your Honor, I'm sorry. By the phone extractions, Your Honor, do you mean the jail call?
No, the 3 search warrants that you had referenced earlier. That information, that by August 8th, the motion regarding the Taint team should be filed on or before that particular date. And we'll put it over for further hearing parties available on August 22nd, 2 p.m.
That sounds fine, Your Honor. Is that a Thursday?
I believe it's Thursday.
Yeah.
Yeah, that's a good date, I think, for both of us.
Okay. Attorney Bradel, is that a good day for you and your client?
Judge, I'm sorry, it's not. 28th available? August 28th?
That's a Wednesday.
So once you want to keep it on the Thursday.
I gotta welcome everybody. Go Taint team.
Is 21st? Oh, I'm sorry. No, my client is not available, Judge. 29th, sure.
And that will be at 2 p.m.
August 29th?
Okay.
That's
Mr. Carney, your matters are continued to August 29th at 2 p.m. Thank you.
Oh, wow. That's the same date,
Thank you.
I think, of the Idaho. All right. So, all right. I don't even know what to say, guys. There you have it. Wow. This judge really doesn't say much. August 29, 2024, new date. And that, I believe, is the same day of the huge hearing for the Idaho 4, I believe. Maybe it's August 26th. I have to double check. But that's going to be probably a couple days for a change of venue. So anyways, TurtleBoy will be having a new hearing. But before that, August 1st, the Commonwealth has to notify the courts if they can, the Taint team has to get to work here. This is wild, man. I had to start just laughing Matt McCabe just sends me into a whirlwind. Matt McCabe. They were asked questions at a damn lacrosse game. Okay, nobody was threatened. Nobody was harassed. And then he was like using his phone to like get in front of like TurtleBoy's phone. Just wild. So the judge, just sat there, listened to it all. Okay. 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 So, I mean, the Commonwealth just does whatever the hell they want. And nothing is going to change unless the judges start fucking hammering. You know, if the judges aren't going to, you know, so. Yeah, see, Sarah, there you go. My memory serves me right. Those numbers just don't pass me by. Breaking it all down is TurtleBoy wants the phone records of LG, Lindsay, and I think that he should get them because in the police report it said that they were deleting text messages. Like that's deleting evidence. That's your. That would be obstruction of justice. They're committing a crime, but she's doing it with Mello, the special prosecutor in his case, and Tully, the investigator in his case. And they set up TurtleBoy and in order to arrest him based on violating his bail, his rules when he would be out. And that's how they were able to throw him in jail right before Christmas time for 60 days. Ridiculous. Absolutely ridiculous. But this is so serious because he's facing a shit ton of felonies because Tim Bradel said it right there at the best. They're just inventing crimes. He didn't commit a crime. Like, what did he do? So, God. And you know what? Mainstream media needs to be covering this because, like, they're journalists. And if they're not, and they're not getting involved with this, and shame on them. Shame on them. And that's why all of you guys that are mainstream media have went to YouTube and started up your brand and your little channels on YouTube. Why? Because we were owning your asses. And that's why you came to YouTube. So y'all that think that you're mainstream media, you're on YouTube now. Vinny started up a YouTube channel. He's on YouTube. What is he? I think he's a YouTuber now. So I think it's just interesting. But everybody mainstream media wise, what they start doing in the past, literally like the past year, coming on over to YouTube. So MSM journalists, YouTubes, they're all over here. So, but we support TurtleBoy. We support the First Amendment, and the Commonwealth of Massachusetts is embarrassing. Period. So, I know that TurtleBoy has like a defense fund. You guys can donate to that to help him out. They're going to take this to trial. I think this is going to trial, and it's just wild. It's just wild. But thank you guys so much for being here, and that's going to wrap it up. And I'm sure I'll have more to say after I can digest all the fuckerage. But it was really hard to focus when Grandpa was talking. I'm not gonna lie. So I need a minute. My ADD was kicking in, so I need a minute. It's really hard to, Bradel's like Alan Jackson, like spitball and shit, and then you have Lally. I mean, I think they hire in Norfolk County sloths. Okay, right. Peace out, Girl Scouts and Boy Scouts. Thank you guys for modding. Love my mods. Members, subscribers, on your way out, hit the thumbs up. Peace. Make yourself known. Use the comment section of the video. Tell me what you think, but this is crazy. And Lindsay, shame on you. Your dick was slipping through your hands and in the hands of Margaret, and you did all this, or Meredith, and you did all this. There's plenty of dick in the sea. Go find some. Shouldn't be hard. Paul Keith seems to want your support. Peace.